Hello, everyone, and welcome to CLI's Legal Generative AI Summit 2023. I'm Terry Modishead. I'm the Executive Director of the Centre for Legal Innovation at the College of Law and have the great pleasure of being your host and the facilitator for this session. I would like to acknowledge the traditional custodians of the lands in all the places on which we meet for the summit today. We pay our respects to elders past and present, and we acknowledge all Aboriginal and Torres Strait Islanders peoples joining this session. We also acknowledge and welcome all First Nations people from every country joining us for this session. We have got a jam-packed session for you. It's titled Legal Professional Responsibility in the Digital Age. Critical, outdated, or redundant. It's a complicated topic, but looking for uncomplicated answers. And we're certainly going to focus on getting to those for you today. It's also an all-encompassing topic. It kind of covers our entire legal ecosystem, but there's also very personal and individual implications from the sorts of things that we'll be discussing today. We've got lots to get into, and we have a truly amazing panel. So let me introduce them to you and welcome them. Matt Dunn, who is the General Manager, Advocacy Guidance and Governance from the Queensland Law Society. Welcome, Matt.
Thank you.
Catherine Gleeson, who is a barrister and also the New South Wales Bar Council member and Deputy Chair of the New South Wales Bar News Committee. Welcome, Catherine.
Hello.
Jeannie Patterson, Professor of Law, University of Melbourne and Co-Director of the Centre for Artificial Intelligence and Digital Ethics at the University of Melbourne. What a great name for that centre. Welcome, Jeannie.
Hiya.
And last but certainly not least, Jennifer Shaw, who's a partner at Bhatia Perry Lawyers and a panel member of the New South Wales Law Society's Professional Conduct Advisory Panel. Welcome, Jennifer.
Hello, everyone.
Well, again, folks, welcome. We've got some stuff to talk about today, right? Quite a bit. And I wanted to jump in kind of with a really broad question, and it's this. Has generative AI redefined professional responsibility and ethics in contemporary legal practice? And Catherine, no pressure, kick us off on the response to that one.
Thanks, Terry. For my part, I don't think there's been any redefinition of professional responsibility and ethics as a result of generative AI. What we've encountered at the Bar Association is, just as often happens, there's a development in technology, in social interactions, in the law, which gives rise to a new context in which professional responsibility obligations need to be considered and applied. What we have done is look at the way in which generative AI can assist in legal practice and think about how that runs up against some of the well-recognised duties that legal practitioners face. For our part, what we've identified, and this comes very strongly from the perspective of barristers and the particular obligations that we face, insofar as barristers under the New South Wales Bar rules, which is where I practice, have obligations of independence, an overriding duty to the court, and a duty to conduct legal services with competence and diligence. The use of ChatGPT, particularly to do things like generate advices, undertake legal research, matters of that nature, have run up against those particular matters. And what we've sought to do is to focus practitioners' minds on the fact that when using GPT-based services, that it's very important to keep in mind, having regard to the way GPT works and some of the vulnerabilities that we are experiencing in the way that it operates, that the work that is being done is your own work, is the exercise of your independent judgment, that you are making sure that you're disclosing the use of GPT services, that everything that is produced by a GPT service is then thoroughly checked and vetted by you and is utilised as a tool that ultimately produces work that is your own and involves your independent judgment. And also that you're not using ChatGPT in a way that could run you into trouble with disclosing confidential information that you're obtaining as part of your legal practice. What we have done is issue a guidance note for the New South Wales Bar Association on the issues that can be encountered. You can find that on our website. I can go into it in more detail in response to a question that might arise later, but I think I've spoken too much now, so I'll hand on to the rest of the panel.
No, never. I think it's really, really important. So for you, I guess, if I was to summarise it, it's kind of more context than content, and that's what the guidance note is focusing on.
That's absolutely right. It's just a matter of making sure that you've got in mind the existing rules and you're applying them to the new context of the availability of this tool.
Yeah, but you folks are still one of the few bar associations or law societies around the world that have actually issued some sort of guidance in whatever form. And so if I may just ask a little follow-up question on that, what prompted you to do that? Because it's a real leadership position on this.
I have to say, despite having worked on this, I couldn't tell you precisely what the genesis was, other than to say that it was a concern of our executive and it was concern of our I'll call them, because I can't remember the precise name, our technology committee, which deals in various ways in which members of the New South Wales Bar can engage in technology in their practice, and also engage in areas of practice that deal with technology. That then came to the Bar Council as something that needed work to be done, and I worked on it in my capacity as a member of the Professional Conduct Committee. But it was something, as far as I know, that didn't arise from there being a complaint or anything about a practitioner using ChatGPT. It was identified that it was a new tool that could be utilised in a number of different ways, and that it was germane of us to try and make sure we're guiding our members on the appropriate use of it in the context of their professional obligations.
But really interesting that it involved not just lawyers from the get-go. You also had your IT people kind of involved in
well, the technology committee are barristers who like technology. And so certainly for my part, it involved a lot of self-education as to how it is that GPT models work. I was certainly a Luddite in the area until such time as I started working on the document that we produced.
Fantastic. Thank you for that. I'm going to ask this question of all of you because I really think it's a bit of a scene setter for what will follow in our discussion. But Jeannie, I guess to some extent, some of this is in the name of your centre. So, has GenAI redefined professional responsibility and ethics, do you think?
I'm going to go the other way and say yes. I think it's a fundamental change. And the reason I think it's a fundamental change is because technology such as ChatGPT, generative AI, but also predictive models that we're also seeing being used in the law, changes the origin of information, it changes the speed of information, and it changes the presentation of information that's available to lawyers and also consumers of legal services. And I think those changes are actually so significant that I'd sit on the line of, yes, it has changed professional duties, and in particular professional duties about how we do exactly what Catherine just talked about, which is to understand enough about the technology to know what the risks are. And I think that is something new. I think this, and for the reasons I've mentioned, I think it is a challenge to lawyers. And I'll give you an example. I'll give you two examples, actually. One is last year I was teaching students. I teach a course on technology and law, and we gave them GPT. We gave them GPT-3, I think, and they had to use code to access it. 3 months later, it's sitting in effectively an app. That is a huge change for how we get hold of information that's been run through large language models. And I don't think we should underestimate that. ChatGPT operates in ways most of us still aren't familiar with. We've seen a lot of exaggeration in the press. We're told ChatGPT hallucinates. ChatGPT does not hallucinate. Hallucination is something that attaches to people who are sentient. ChatGPT has no ground truth. It's a word predictor. And that sort of insight is really, really important to how lawyers in particular use the technology. And that's why I say it's a new duty.
And I want to come back to that, and I will, because there is a common thread in what both of you said, which is around that education piece and awareness raising as well. But let me jump to you on this one, Matt, as well. Redefine professional responsibility in contemporary legal practice, or no?
Look, Terry, I think I'll go a bit of 50-50 on this one. So look, I think from the solicitor's perspective, what it doesn't do is it doesn't change those core duties of competence, diligence, supervision, the duties to the court, the administration of justice, the obligation to maintain client confidentiality, to work in the best interests of your client, those fiduciary duties, that element. I don't think that's what we're talking about really today. Those things are really important principles, and the way you will have to maintain those principles is going to be challenged. And I agree with Jeannie about with ChatGPT, but I think where the frontier is, in my head at least, is around how do we take and educate the profession about what is the new technology and the opportunities that it presents, the pitfalls that it has, and how really it should be used. And it's also, I think, going to be a little interesting to see how acting in the best interests of your client might change in terms of leveraging some of that digital labor. And I think that's probably a point that is going to come out a little bit there. And I think that's going to struggle. I think our regulation model that we've got at the moment is going to struggle a little bit with that. And I think it's going to burst a bit at the seams. We could probably talk about that a bit later on, but I think, some of those foundational duties about what it is to provide legal services or what it is to be a lawyer are still as relevant today as perhaps they were 500 years ago. But I think the way we're going to deliver those services is definitely going to change. And some of that's going to cause us a little bit of consternation, I think, in terms of that. And flow-on effects in a number of different aspects, like how, for example, we're going to go and do billing when we're using digital labor to produce some of the work that we are producing, and how we go about presenting bills and how we fairly bill our clients, how we bill for value, perhaps more than how we bill for time. There's going to be some interesting challenges I think it's going to throw up that we're going to have to respond to. And really the crucial part of that is going to be understanding that technology and understanding the benefits and the pitfalls in terms of how to engage with that technology.
Yeah, and I'm wondering, Jennifer, if ultimately we're trying to fit a square peg in a round hole, or maybe we're just shaving off the sides. I'm not too sure, but I'd love to hear your thoughts on that.
Well, having listened to all those opinions, so I do agree with Catherine. I think the obligation to know what the risks are with this technology falls within the ambit of the current conduct rules to deliver legal services competently and diligently. And we already have in place a legal framework with professional obligations, and I think those remain the same. But I completely agree with Matthew that what's necessary is to ensure that legal practitioners are aware of how the technology works, that they're mindful of their professional obligations when they're using the technology, and to ensure that they don't inadvertently breach their obligations. And in that regard, I completely agree that we do need to consider what we're going to be doing in terms of educating the profession, whether that's by guidelines such as those that Catherine's been involved in preparing, or also maybe some mandatory obligations around continuing legal education. We already have for solicitors, and I think barristers too, a mandatory continuing legal education unit, which is 1 hour per year for Australian solicitors and barristers in ethics. I don't see why we couldn't have something similar in and around technology and AI. It could be quite broad to allow for practitioners to pick an AI topic that fits with their particular legal practice, because for different practitioners it's going to be different. And it's no different to what we do now with ethics. We have ethics lectures on all number of things, ethics in private client issues, ethics in property matters, or whatever it might be. And a particular lawyer can choose which topic in ethics they think might be most relevant to their practice. We could do something similar around AI.
Hold that thought, because I want to come back and explore that whole idea about, mandatory tech competency, etc., a little later. So we will come back to that, I promise. I wanted to, in the next part of this, get into what is often considered the nitty-gritty of this discussion. And I'm just going to summarise it by saying unauthorised legal practice and throw out a few statements that I think are not in dispute, but, you know, please do dispute them if you would like to. And that is, I think everybody is pretty much in agreement that we need better access to justice. The figures differ a little from country to country, but overwhelmingly, we don't have the people, most of the people that need some sort of access to legal advice or problem solving, able to get it for a bunch of different reasons as well. I guess as we look at generative AI and picking up on some of the threads of what we've just been talking about, there is the opportunity that it will assist with self-serve options, or that it can sit alongside with the assistance of a paraprofessional that would be able to, that combination individually or together, to help consumers in a general context have access to more information and support and advice and help in relation to legal matters. So it's a big, big topic, and I'm going to pull it apart a little bit at a time and kind of lead us through this. I'm going to go wide and then go narrow. And I'm going to ask this one of you first, Jenny, if I may, and that is, looking at it at the 40,000 metre view, is the starting point that we have to change the regulator mindset. And by that I mean from, you're not allowed to do that, therefore we're going to basically stop you doing that, to we've got to find a way to close the A to J gap. We have to find a different way, because it's not the same way of thinking. What are your thoughts on that?
Well, I sit in an ivory tower, of course, being an academic, so the 40,000 is probably a good one for me. But I think my answer is actually similar to, does ChatGPT change the nature of legal duties? I actually think AI does change the way we practice law, and I think it does change the way we regulate law, but perhaps not in the way people would expect. We always have this pipe dream that we're going to fix access to justice through a new technology, and I think the reality is we're not going to fix access to justice just through a new technology. And this is because we need lawyers to fix access to justice, and so we need lawyers who can work with the new technologies to provide a better service that is not an inferior service or the mere provision of information to individuals. So an AI might be able to be trained to narrow down the nature of a dispute. And I know that Justice Connect here in Melbourne is working at that. There's Justice Connect across Australia, of course. So Justice Connect is working at training AI, training something that uses a large language model to be able to identify the nature of a dispute, which is really useful to people coming into a legal service. But it's then up to the lawyers to take that information and do something with it. I've got a PhD student actually looking at this question, and access to justice through technology happens through deliberative design by lawyers who understand the limitations and the capacities of the technology, not by accident.
But I think what you're saying, but do correct me if I'm wrong, is that you have to be open to that. You have to fundamentally be open.
Sorry, I agree with your starting proposition, and actually I think there's a role for the regulator to prompt that move, to prompt lawyers to be very transparent about how they're using technology, and in that way how they price their legal services. And I think there's also a role for the regulator to prompt lawyers to take up the technology. And I don't think we should leave that to accident. Thomson Reuters did a survey about how law firms are using ChatGPT, and 47% of law firms had no plans to look at AI in the near future. So again, these things don't happen by accident. Yes, Terry, I agree with you. It's a role for the regulator to lead that.
Jennifer, the nature of the work that you do for barristers and solicitors is basically acting for them when they've unfortunately not managed to get everything right. And so for me, it's kind of an interesting perspective that you might have on this question. Is there a need for the regulators to think about things differently before we get into the nitty-gritty?
Well, when you talk about the access to justice gap, I mean, legal services are available in Australia already on a pro bono basis for individuals who meet those pro bono thresholds. And certainly at Barty Perry, we offer a lot of pro bono assistance. But if AI, and I agree with Jeannie that if AI makes the delivery of legal services more efficient, then that might mean that law firms have more capacity to assist with more pro bono matters. As to unauthorised legal practice, there's no prohibition on individuals representing themselves in matters. And in fact, I was thinking about this, that self-represented litigants, if they were to use ChatGPT to assist them to produce some of their legal letters and court documents, we might actually see an improvement in the standard and quality of some of those documents. I'm not sure. But unauthorised legal practice, though, is quite different in the sense that that's where a third party is seeking to profit from holding themselves out as qualified to provide legal services when they're not so qualified. And in Australia, that is a criminal offence.
We're definitely going to get to that.
Yeah.
So hold that thought,
Yeah.
because I do want to kind of get to that bit if I can just a little bit later. And thank you for that. Matt and Catherine, I wanted to address this next question to you, and Matt, you first.
Okay.
And we're getting kind of, or picking up where Jennifer kind of started down this track, I think, which is, should we, or is there a compelling reason for us to safely experiment at scale with new or different providers? So I'm thinking here of, for example, the regulatory sandboxes that we've seen emerge in the US and UK and Canada, where, to go to the point that Jennifer was making, these folks are not necessarily legally qualified, but they are assisting and going beyond potentially what we may have traditionally said was giving information. They've actually stretched over that, or it's blurred into almost the advice bit. Do you think that we should all be thinking about that, no matter where we're located, because there are different needs for people now?
Thanks, Terry. That one's a great question and a confounding one too. So I'm grateful to answer that one first. It's a complex issue, and if we look at it from access to justice aspects, we've got a lot of different moving parts in the particular access to justice issue. We've got, in terms of how we get, say, criminal representation into Mount Isa or into the Timor Strait or into Thursday Island. We've got one particular types of problem. We've got a different type of problem accessing, say, civil justice for a lot of folk who are in the middle, missing middle, too wealthy to get legal assistance, but not wealthy enough to be able to afford full service lawyers. And so we've got a lot of drivers with different types of problems in this particular space. The interesting question then, do we go to sandboxes? Do we go to increasing the net, in order to provide that? Look, economic theory would kind of suggest that if you have more service providers, you'll lower the cost and you'll provide more services. That's been the kind of dominant paradigm in the legal profession regulatory sort of system in terms of the way things are structured over at least the last sort of 10, 15 years. And it's done a reasonable job, but it really hasn't brought the prices down that much, but it has increased supply of the number of lawyers in Australia, but it hasn't fixed the access to justice gap. I think what's interesting is perhaps to look at it from the perspective, especially in the solicitors branch of the profession. We're already experimenting at scale a little bit with different models here in Australia. The incorporated legal practice, for example, is actually a little bit different and revolutionary in terms of a lot of other jurisdictions. But what it's also enabled legitimately is some of those paraprofessionals to be able to work in law firms with a legal practitioner director and to be able to offer services. And we're seeing a lot of that on the ground. So there's kind of a multiplication of the effort factor there from lawyers in terms of the number of practices out there. But ultimately, I don't know that it would be a bad thing for us to have the ability to be able to push the envelope a little bit further, because what we risk is pushing out the current regulatory model that we have, which was kind of built for a more Victorian type of era, and we'll miss all of these folks offering services. And what we don't want to end up is a kind of an Uber situation, and taxis where, we stick to a kind of regulatory model that has worked over a long period of time, but we just get, overwhelmed and completely disrupted. And at the same time, we also need to remember that the whole purpose of this regulatory system is the public good and making the best interests of. So what we want is we want people to get good quality legal advice, not just be able to get legal advice, which, as Jenny said, it isn't potentially hallucination from ChatGPT, but might be misprediction and misprognostication. So it's not even, I think, just a matter of like legal advice at all costs. It's got to be, how do we deliver quality, and how can we make sure that people are getting a good result?
So I'm going to play devil's advocate there. It probably won't surprise you. And Catherine, I'm going to throw a twist into this and see what you think about it. If we do kind of take those stats and we accept for the moment that legal services are available to maybe 10 or 15% of the public, because we're not meeting the other unmet need, it throws a question mark over who we're protecting, because we're just not getting to the majority of people that need access to those services, I guess. So, and it's been suggested that for folks and what generative AI could potentially produce, that what that could deliver is still better than nothing. And maybe one way to approach that is to think about different levels of service, albeit that it would place a greater emphasis on the individual consumer, perhaps to do things like waiving or giving consent to a waiver of privacy or confidentiality issues. And I'm going to assume for the moment they may or may not be fully informed. It's a big one. But what I want to push back on, I want to get your thoughts around this, Catherine, is that the regulatory sandboxes have grown up because there is a huge unmet need. And us saying that we are protecting, and we are really only protecting 10 or 15% of the general population, is not good enough now in the current state of play. So if I may, Catherine, that's a big one for you. What are your thoughts about that?
My general thoughts about it are that there are a whole lot of different ways that people are denied access to justice. I'm a litigator, so I usually see it at its most acute with people like people who are involved in family law disputes or in criminal proceedings that are not sufficiently serious that you would either just stump up the money for a lawyer or qualify for legal aid. Matters that are of great seriousness because there's very much at stake. There's a whole lot of other areas where access to justice is less of an impediment, for example, in estate disputes or personal injury matters, because we've already developed solutions like speculative work, so that you don't assume some of that risk. Some of the models that we've already seen emerge with the use of technology, even if it doesn't involve AI, involve things like making it easier and easier to generate simple legal documents, things like wills, simple agreements for businesses or things of that nature. We've also seen already a division in the provision of some legal services, for example, with registered migration agents and licensed conveyancers, so that we already know that we can kind of strip out some of the more simplistic things and make those products available in such a way that either you've got a little cottage regulator that just deals with a particular service provider, or that you might have lawyers do things like, and one example I can think of is that there's been a few examples in fines litigation where there's a very simple answer because something's gone wrong with a fine on a large scale basis, and you can produce the defence either by running it for a whole bunch of people together or by teaching them how to defend themselves. Now in that, the only scope I can see for a regulatory sandbox type model is in that last example, the effectively assisting people to defend themselves. There's obviously going to be some need for regulation. If you're using lawyers, you probably don't need a regulatory sandbox, but let's say you've got some people who they run a business, they're involved in AI, they're using lawyers to generate some kind of product that would allow people to access self-advocacy tools, as it were, that's somewhere where I could see that you could use a regulatory sandbox to work out whether that is another area of delineated quasi-legal services that could be made available. If you look at the example of regulatory sandboxes in Australia, ASIC's enhanced regulatory sandbox, it's a difficult hurdle to jump to get the regulatory exemption in that example. And you've got to have a lot of things that we're used to lawyers having to have that create barriers to entry for practice, such as you've got to have PI insurance. You've got to be able to prove that to someone who's going to grant you the exemption that you have this model and that it's got a public benefit and that it's going to operate in a predictable way before you're unleashed on the public without your particular licensing requirement. But that's not an impossible thing for the legal services commissioners and regulators in each jurisdiction in Australia to consider doing. It's probably the kind of thing that community legal centres might be quite interested in using AI for. I can certainly see that there is some scope in using that model in circumstances in which the kind of controls regulatory sandboxes usually are used there. My only query about it is I think most of the time there's going to be a lawyer around it. And I think there'd need to be a lawyer involved to make sure that when it's set up, it's properly tested and vetted. But apart from that, if you had somebody who was either an incorporated legal practice or simply a corporation who wished to do those things, I wouldn't think that would be something that regulators would be completely averse to.
Jenny, I wanted to come to you with that because I saw much nodding of heads and while we were talking about that, but also maybe if I can add another string to that bow as well, which is the idea that's starting to evolve here about potentially having maybe one regulator that's regulating a lot of different people or activities, or is it a series of different regulators that are assuming that responsibility? So if I can just add that into the general conversation as well.
There's actually a really nice comment from someone who knows a lot about this. She made the comment that why are we focusing on lawyer-led solutions to these issues of access to justice as opposed to problem-led solutions? And I think that's probably right. I think that what the conversation we've had is heard from people who are experts in this as well, is that the reasons why ordinary individuals have problems accessing justice are different. And the solution is, I don't think it's actually a tech solution. I think it's a solution about what we think the role of law is in resolving those problems. Because there are some places where you do want lawyers because fundamental rights are at issue. And there's other places where the problem is actually quite procedural, in which case we may say that a trained paralegal or another non-lawyer expert could intervene. And in both of those cases, we can use technology to improve the efficiency of the outcome of the person who's providing the service. But I'd be very hesitant to suggest, as I've said a number of times, that access to justice is solved by technology, because we're simply rolling into a situation of, dividing between, some people get good quality justice and some people don't. I think we're much better looking at the need and how we resolve that, and how then technology supports the resolution of that problem. And I'll give you an example. In consumer protection matters, which is my specialty, the law is actually relatively straightforward. And the problem individuals have is actually just navigating the sections, one, so that could be automated quite easily. Then two, persuading the other side to give them a remedy. Again, that could be automated through a letter, but then often pursuing that claim, because often the other side disputes it, that involves going to a court, or in fact it doesn't involve going to court, it goes to some sort of dispute resolution service. And that's often where the bottleneck is. Dispute resolution is expensive, and that's where a person may want some legal guidance to get them through the dispute resolution process, or perhaps they don't. Perhaps they want to stay in a non-legal forum. But I think the point is we break it down from the user's perspective and think about what their needs in obtaining the outcome that they want. And what regulator do we need? Well, we need the regulator that's relevant to the type of service the user needs provided to them, I think.
Yeah, so I think what you're saying is that, yes, we should open our minds to the possibility that it still needs to be somehow managed, but it may be managed quite differently and by quite different people, depending on the nature of the services that we're providing.
Absolutely.
Yeah. Jennifer, what do you think about that?
In terms of the regulator?
Yeah, particularly the last point of, do we need almost different horses?
Different regulator.
Yeah,
I thought about this query, and I think it does depend on what we're regulating. So as for regulating the AI itself and its implementation more broadly, and ethics in AI, maybe we need one regulator to oversee and ensure compliance with that and around security, cybersecurity standards, and have businesses who are looking to implement that AI registered with that regulator and subject to periodic review. And I think from my reading that actually appeared to be a recommendation from our Law Council of Australia in response to one of the discussion papers of CSIRO back in 2019. So I'd be comfortable with that. But as to regulating compliance by legal practitioners with their ethical obligations, though, I think that regulation should remain in the domain of the current local regulatory authorities. So in Australia, we have local regulatory authorities in each state and territory. And I don't think a complete overhaul of those regulations is necessary. Rather, we could just supplement our existing regulations as might be necessary to cover any specific concerns around AI. So for solicitors, for example, we've currently got the Legal Profession Uniform Solicitors Conduct Rules, which apply in every state and territory in Australia, except for I think the Northern Territory have still not adopted them. But I think that those were collaboratively developed, and I think that they could just be supplemented with maybe additional rules that are specific to any concerns that arise as they arise around the use of AI. And of course, we still have in each state and territory as well specialist disciplinary tribunals. And I think that to unpick that framework that we already have in its entirety, I don't think is necessary. But I do think from a general perspective, it would be helpful probably to have a regulator that oversees AI generally across all different industries, including the legal profession.
If I can jump in there, there's actually an inquiry. So Jennifer's point about the regulator is a really, really interesting one, because there's an inquiry at the moment, and one of the suggestions is that we have an AI regulator. That was also a suggestion actually that came out of the RoboDebt inquiry, that we have some sort of regulator that provides that technical expertise that we've all kind of agreed is necessary at some point, while leaving the sort of domain specialist regulators to apply to particular markets or professions. And I think that's useful, but I still think all regulators are going to have to be able to talk the tech talk as well, without becoming coders, of course. But it's a model we already have. In fact, I would actually remind people that even lawyers are subject to the Australian consumer law, in fact.
And it is also a great segue into the next question that I have, which is picking up on something that Jennifer said earlier as well. And I wanted to, Matt, address this question first to you, if I may. Are we at the point now where we've got to basically mandate some sort of tech or AI competency? It's picking up the comment that you just made then, Jeannie, as well. Or is that going too far? And I'm thinking, obviously, in this respect of what's been going on in the US about recommendations which are mandated or not, depending in each state. Are we there? Do we need to mandate it? Do we need to have the specialist training like we do for ethics that Jennifer was mentioning earlier?
Thanks, Terry. Look, if we're not there yet, I don't know that we're very far away.
Okay.
You know, we've come to a point where that fundamental duty of competence and diligence that we discussed before, which is pretty important. In order to give life to that, these days, you really have to be able to use technology. You really have to be able to manage technology, and you really have to be able to know enough to be able to select the technology that's going to be right for you. And that's certainly what we found through the Future Ready research that we have done up here in Queensland, looking at small and medium-sized law practices with USQ and UQ, that, you know, that requirement or that need to understand the tools of the trade, and the tools of the trade now and for the future is going to be data, technology, online systems. And from the work that we do with a lot of our practice advisory service visits and otherwise, the selection of technology, the use of technology is one of the biggest concerns. And so you kind of look at that and go, you know, once upon a time, in order to be able to do their work, a lawyer needed to be able to drive a pen, you know, but in order to be able to do their work for the future, a lawyer is going to need to understand how their practice management system is going to work, how they're going to use augmented drafting, or how they're going to use, you know, expedited legal research, or how they're going to need all of these different elements to be able to fit together to be able to provide the services that they do. So I'm conscious of what they've done in the US with their competence technology, which has been picked up in a very large number of states there. And you'd sort of have to think that when we think about what the duty of competence and diligence is in Australia, we've got to start thinking about it in that technology aspect as one of those key planks.
Yeah, absolutely. I want to jump into the questions, but first, Jennifer, just wanted to get your thoughts about that, because you started us down this wonderful thought process around tech mandating or not the competency. So jump in and let me know, and then we'll jump to the questions.
Oh, look, yeah, look, I completely agree with Matthew. And I think given the pitfalls for legal practitioners, including practitioners that I represent who are on the receiving end of complaints and disciplinary procedures, I think that it can only help to have some training and a mandatory requirement to have some training and keep up to date. And that will hopefully result in less issues and less complaints and less even legal proceedings arising out of use of AI inappropriately.
Yeah, fantastic. Let me ask this question, and I'll ask it of you, Catherine, and it's one of the questions that we've got here. Can the regulator drive AI adoption without the assistance of the compulsory legal professional indemnity insurers? So in other words, does it have to be a collaborative agreement around that, or is it something that one can do to the exclusion of the other? Do you have thoughts about that?
Without having any special insight into the decisions that are made by indemnity insurers about whether or not they provide us with coverage and for how much, I think it will really depend on the scale of the risk that any big change presents. If it's going down the road of lawyers are still doing the work of lawyers, but they're doing it in a different way, the only thing that's really going to change any appetite for professional indemnity insurers to provide coverage is if all of a sudden there are a whole lot of professional conduct complaints and negligence suits.
Yes.
And we're just going to find it a lot more difficult to get cover. If it's a matter of us, of the legal profession or professions generally seeing a new avenue of business that is either related to or involves the provision of legal services, then obviously professional indemnity insurers are going to be interested in that, and probably going to be interested in the mode by which it's regulated. Just to take one example, whether or not the professional standard schemes need to be in some way moderated to make sure that the limits that we all tell ourselves that we have are going to continue to be applicable, then that's another thing that regulators and the profession will need to engage with.
Absolutely. Jenny, I want to address this next question to you, if I may. How do you see generational differences in lawyers and those reluctant to adopt technological change as impacting on leadership in the law? moving forward in this kind of AI paradigm?
Well, I think it's a really important, interesting question, but I don't think it falls the way people might think. I think the assumption is that older people like myself are anti-technology and younger people are very pro-technology. There is some statistics on this from Thomson Reuters, which is the survey I brought out earlier. And in fact, the sort of people who were most enthusiastic about the role of technology in law firms were partners, and the people who were most nervous were junior solicitors. And I don't think it's hard to unpack why, because the work that AI will do in legal practice is the work that's done by junior solicitors. So that, in fact, they're the ones who are perhaps anxious, where perhaps partners are keener about embracing it. The comment, though, that I would make, aside from not making assumptions about age, is that the problem we have is the technology is changing really quickly. We at the law school are constantly told, why don't you train students in? And my answer is, if we did that, by the time they got into practice, that would be out of date. So I think the biggest challenge to the legal community is actually how fast the technology is changing. And we need to kind of agility and mindset in how lawyers deal with technology, rather than just teaching lawyers about particular technologies.
Absolutely.
And Terry, I would say that is some of the work I see you doing. So well done.
Well, thank you. Jennifer, I want to address this question to you because it kind of picks up on some of the things that we were talking about earlier. And it is, would you consider it unethical for lawyers and the judiciary skills to remain siloed when cross-disciplinary and technical understandings are increasingly important and relevant to day-to-day functions?
The thing is, it depends which area of practice you have chosen to specialise in. So legal practitioners in Australia are required to undertake 10 hours a year of continuing legal education, and the ethics component. There are various components of that are compulsory, and the ethics component is one of them. So, and the other, some of those other areas should be around the area of practice that you practice in, because the law is constantly changing in all areas. So the whole point of the continuing legal education, as I understand it, is to ensure that you are competent and up to date in all areas of your practice. So all I was suggesting earlier is that because of the impact of AI and the need for all lawyers, I think, to get across it or face potential pitfalls of misunderstanding how they could fall foul of their conduct rules by use of it, that it would be helpful to mark that importance by ensuring that one of those key competency areas is to attend at least 1 hour related to an AI topic, and those AI topics don't need to be specific to project management or specific to one particular type of AI. I think you'd have a range of topics available each year, and you would be able to choose to attend one of those that's relevant to your area of practice. So the onus is on the individual lawyer to do their continuing legal education, to keep themselves up to date, to remain competent and diligent in the work that they do. So that's really what I was driving at.
Fantastic. Catherine, I want to pick up another one of these questions here, but also to pick up the point that you were making earlier in a broad context of self-represented litigants. And the question is that ChatGPT or other similar products that folks can use could impede access to justice by flooding the courts with vexatious claims. So we know consumers, for example, are using these at the moment to help with lodging complaints or court documents, whatever the case may be. As a barrister in particular, what are your thoughts on that?
I suppose I have two perspectives. The first is based on my experience, which is common with most practitioners who regularly appear in courts, state and federal, is that there is just an unstoppable flow of self-represented litigants, both by necessity and desire. Their access to legal resources is because of wonderful enterprises such as Ostley, pretty comprehensive. So, you know, where there's a will, they're going to be in court using whatever resource they have. I wouldn't necessarily think that the use of GPT type tools is going to fundamentally change what we call, you know, the died-in litigants. When it comes to people who are more likely to appear in the lower courts, it may well be that the availability of better and easier to use resources will mean that more people are who are going to find it tight to brief a lawyer might start trying to do it themselves with the use of these tools. The accuracy or otherwise of those tools might create some downstream problems of volume, but at the end of the day, there are only as many people as there are court cases. We, for both fiscal reasons and because of what we do for the administration of justice, would prefer that people have lawyers. But if they've got access to a resource that is going to provide at least some guideline for what it is they're supposed to do in a court, I wouldn't necessarily think that the use of such technologies is going to create some floodgate that we should try and stop. I think it's going to help more than it will hinder. And when it comes to people who are uneducated in the law coming to courts with things that are misguided and just reflective of their ignorance of what is a highly specialised profession, aren't going to change. That's just a problem that we have to face, because some people want to have the fight themselves and some people need to.
Matt, I want to return to this question of education and pick up some threads from some of the questions that are there as well, and also to some extent connect that with the idea around to have or not to have mandatory requirements around tech competency. Who's going to train all of these folks? And I'm thinking, you know, if we think about any sort of tech competency, to pick up Jennifer's point, choose which one you want. If we think about any of it, the sheer scale of this is just phenomenal. So I just wonder, because I know, you know, at the Law Society, obviously you have a strong focus on education and supporting the profession in that respect. Who's going to take this on? Or given the reports that you've referred to, is this now a continuum of change where education has to sit in a bunch of different places and we have to start today?
Thanks, Terry. That's a big one. So
saved it for you, Matt.
Thanks very much. That's great. Look, the problem is there's probably more to do than there is time, you know, and there's more to do than can reasonably be done. When we did the job readiness research with Bond, we came up with a competency framework. It had, you know, 50 plus competencies in it, plus people suggested a few more that should go in. That was probably more than, you know, even a 10-year undergraduate degree could probably fit in. And that's a very difficult situation because you can't do everything. And I think Jenny was right. You can't train people on everything operationally. You've got to give people the tools to be able to learn themselves, to be able to grow, and you've got to be able to do that. I think reasonably, we've got to start to look at our CPD system in terms of the way that we help people to grow some of these abilities and competencies. I don't know that a tech competency, if you just look at that little vertical, has to be a complete understanding of leak, smokeball, action step, and how it works inside as a relational database. But it's got to be enough to understand how technology works and where the levers are and where the things are to pick up. You know, we've talked a little bit today about Chat GPT and large language models being text predictors. You know, I think in order to engage with AI, you need to understand a little bit of that to then understand why you get results that are sometimes a bit screwy, you know, and so that you use it for the purpose for which it's really meant. So I think there's some fundamental underlying stuff that we need to do a much better job of teaching people about. We need to look to, you know, probably we need to look at our preparatory education for prior to admission, but we also need to look at our CPD scheme going forward. We need to have a bit of a look. We've got business skills as one of our core mandatory elements, but we don't really specify what that is necessarily down to a lot of, you know, minutiae. Perhaps we should look at that. So I think there's a lot of, this is the part I think of an ongoing kind of process where things have changed quite a lot, and they've changed a lot already. I mean, if you look just, for example, at the world of, say, residential conveyancing, for example, we now have in most states in Australia mandated e-conveyancing done electronically, which was an absolutely unforeseeable world 15 years ago, when we're all doing paper and checks and we're going to settlement rooms and handing things around and doing that. Things have moved so quickly and so far that that's just the beginning. And it's going to keep changing a lot. And we've got to make sure that the education and training that we keep doing and people keep digesting actually just keeps up to date with that stuff.
Yeah, absolutely. Folks, unfortunately, we have to wrap, but I wanted to do that by coming full circle on today's topic. Those words, critical, outdated, redundant, three really different interpretations of legal professional responsibility. So in a rapid fire round and with a rapid response, I'm going to ask each of you which word do you favour, or perhaps not any of them, and why. And Jeannie, I'm going to start with you on that one.
Okay, so I'm going to choose my own word.
Okay.
And I'm going to choose reform, because reform, because everything we've heard suggests to me that we can't just tinker at the edges. We actually need to think about new ways of thinking about legal skills and legal practice. And I think we need to bring technologists into our practice, because we need more minds to keep up with artificial intelligence.
Okay, so multidisciplinary practice is here to stay. Catherine, what's your word, or what is your own word?
I'm happy to pick a word. It's critical.
Okay.
It's always critical. It hasn't become any more or less critical because of changes in technology. All we need to do is to then pick up on Jeannie's concept of reforming and adapting if we need to those new situations. But the fundamental public interest drivers of us having a regulated practice do not change, and the nature of our duties and obligations don't change either.
Fantastic. Thank you. Matt, you're next up. Your word and why?
Thanks, Terry. I take critical as well, but I think the interesting thing is what compliance looks like might change over time. The fundamental principles are really important and there, but how we get to the end point of that and what it means in an ongoing world of disruption and change might look a little bit different as we go on.
Fantastic. And Jennifer, the last choice of word and comment is yours.
Yeah, well, I complied with the rules and picked one of the one of the words that are available. So critical, and so I agree very much with Catherine and Matt, but I also agree with Jeannie in the sense that I do agree that reforms needed in places as well to get up to speed with these rapid changes in AI and ensuring that our training and education and where we need to tweaking of regulations meets this change. It's critical to the protection of the public, the protection of the reputation of the profession, the public's confidence in it, and critical to the administration of justice.
Fantastic. So professional responsibility and ethics here to stay, maybe with different regulators and different regulations, but definitely here to stay, folks. Thank you very much indeed for your time. Really, really appreciated it. I know that we couldn't get to all of the questions, but I also know these folks are incredibly generous with their time. So if you reach out to them, I'm sure that they will answer any of the individual questions and queries that you have. I do hope that you enjoyed this session. It will be available on video in CLI's free resource hub, and it will also be available as an episode of CLI's Legalpreneurs Sandbox podcast. So if you want to receive information about the work that we're doing at CLI, please do follow us on LinkedIn and all other social media. Thank you very much indeed again, folks, and looking forward to seeing you again very soon. Thanks again. Bye.
Thank you.
Thank you.